Hello and welcome. I want to begin by broadcasting the names and personal histories of the 28 pedophiles contained in a long suppressed Australian police document, along with the identities of the planners of the false flag attack of 9/11. But of course I can't. Why? Because the deep state architects of evil maintain a vice-like grip on key information that, once exposed, will bring them crashing down. Now, let's just put a bookmark here and return later in the report. I recently posted a video emphasising the importance of the separation of powers. Further to this issue, we must examine the fine print of section 72.2 of the Australian Constitution, which is crucial to removing miscreant judges from the High Court and other federal courts. It states that justices shall not be removed except by the Governor-General in Council on an address from both houses of the Parliament in the same session, appealing for such a removal on the grounds of proved misbehaviour or incapacity. Section 72.2 is designed to protect the independence of the judiciary by ensuring that the judges cannot be removed arbitrarily. This provision requires that both houses of Parliament agree to the removal, and it must be based on specific grounds of proved misbehaviour or incapacity. This ensures that judges can perform their duties without fear of political retribution, maintaining the separation of powers between the judiciary, the legislature and the executive. So what then constitutes grounds for removal? Such grounds are limited to proved misbehaviour or incapacity. Misbehaviour can include improper exercise of judicial functions, neglect of duty, conflict of interest, or conduct that undermines public confidence in the judiciary. Incapacity refers to an inability to perform judicial duties due to mental or physical infirmity. Regarding protection from arbitrary removal, Section 72.2 stipulates that judges can only be removed by the Governor-General in Council following an address by both Houses of Parliament for proved misbehaviour or incapacity. This requirement ensures that judges are protected from being removed due to political pressure or dissatisfaction with their decisions, thus maintaining their independence from the legislative and executive branches. There's a notably high threshold for removal, citing a clear necessity for proved misbehaviour or incapacity, sets a high benchmark for removal, making it a rare and serious action. This provision ensures that judges can perform their duties without fear of removal for unpopular decisions, thus reinforcing their ability to act impartially and independently. The process involves both Houses of Parliament and the Governor-General representing the executive. This multi-step process ensures that any decision to remove a judge is thoroughly considered and not taken lightly, further protecting judicial independence by requiring a broad consensus across all branches of government. It does not, however, excuse or tolerate conflicts of interest, as unmistakably evidenced within the case in point. The framers of the Constitution deliberately designed Section 72.2 to provide greater security of tenure compared to other jurisdictions such as the UK or the US, where removal processes might be less restrictive. This design reflects a commitment to judicial independence as a fundamental principle of governance. Section 72.2 is a cornerstone in maintaining the independence of the judiciary in Australia, ensuring that judges can make decisions based solely on law and justice, free from external pressures and influences. The removal process involves a formal address by both Houses of Parliament to the Governor-General, who acts on this address. This process is significant because it involves both the legislative and executive branches in a manner that underscores the gravity and rarity of such an action. The procedure is intended to be rigorous and akin to a judicial process, requiring clear evidence and due process. The framers of the Constitution were influenced by similar provisions in other jurisdictions, such as the UK and the United States, but sought to provide greater security of tenure for judges by limiting the grounds and methods of removal. There have been few instances where this section has been invoked, highlighting its role as a safeguard rather than a frequently used mechanism. Nevertheless, such measures exist for compelling reasons and must be used when circumstances demand them. Now, let's return to the bookmark from earlier. Such an imperative occasion is now upon us. It demands urgent, widespread and universally supported action if we are to maintain any semblance of a working legal system in this nation. To the intense consternation of interested parties, in the case of Fitch versus Pfizer and Moderna, Justice Rofe unconscionably failed to mention that she had been Pfizer's lawyer in numerous earlier court cases. Having read the complaint letter, the lawyers for Dr. Fitch have sent it to the Chief Justice of the Federal Court and all the senators and members of Parliament. All familiar with this situation are concerned and alarmed that a judge of the Federal Court would fail to share this very relevant and important information with the parties, especially Dr. Fitch, who's trying to protect Australians from GMOs and harmful injectables. Accordingly, I've shared my deep concern and alarm with my local representative in Parliament, Madeleine King of Rockingham, WA, seeking an appropriate investigation into Justice Rofe's conduct. I sought assurance that she considered the complaint to pass it on to the Attorney General and the Solicitor General. I further requested that she ensure all the senators and MPs are alerted to the complaint, which demands conscientiously undertaking their individual duties to uphold the Australian Constitution when matters of judicial misconduct are brought to the attention of both houses of Parliament. I pointed out that any such investigation can only be initiated when each House of Parliament passes a resolution for a commission of inquiry to be established into the conduct of Justice Rofe, pursuant to Section 9 of the Judicial Misbehaviour and Incapacity Parliamentary Commissions Acts of 2012. A commission of inquiry assists all parliamentary members in executing their constitutional duties under Section 72.2 of the Australian Constitution. Critically thinking and ethically sound Australians should register concern via the website displayed on your screen. Please visit this vitally important site and follow the instructions to notify all relevant parties that this egregious failure is intolerable and must be corrected at once. The insidious influence of Pfizer and Moderna upon the Australian judiciary and the government executive, greatly exacerbated by Big Pharma's unlawful funding and subsequent criminal control of the TGA, must immediately and permanently be abolished. Any rogue judge interfering or blocking this or any other remedial action or information beneficial to the Australian populace requires immediate removal from office. They should also face robust legal proceedings commensurate to their actions. How much longer can we tolerate the brazen assassinations of free energy technology inventors, the hateful suppression of cheap and effective natural cancer cures, the institutionalised protection of known pedophiles, the escalating genocide of lethal injectables, fake medical emergency terrorism, state-sponsored child sex trafficking, and so many more malicious crimes against humanity besides? Our world and everything within it will improve beyond measure the moment we collectively disempower and obliterate the deep state satanic influence and control. This insufferable crime wave must end. So please visit www.section72.au and become an active part of our exponentially growing community defending against this unmitigated evil. We are front and centre in this spiritual war upon humanity, and every internally awake and aware human soul needs to step up and do whatever it takes to ensure our survival. Thank you for watching.